In Australia, copyright protection is free and applies automatically when materials are created. Copyright of published work generally lasts for the life of the author plus 70 years. The copyright notice symbol does not need to be on something to ensure that the work is protected. It does help remind people that the work may be protected. There is no registration system for copyright in Australia. Copyright exists in works and other subject matter by virtue of the Copyright Act 1968, the Copyright Regulations 2017 and the Copyright International Protection Regulations 1969 specify matters related to the operation of the Copyright Act. Copyright protection is provided up the Copyright Act 1968 and gives the owner exclusive rights to license others in regards to copying your work, performing it in public, broadcasting it, publishing it, making an adaptation of the work. This means that no one can do any of these without the permission of the copyright owner. Copyright protects textual material, computer programs, compilations, artistic works, dramatic works, musical works, cinematograph films, sound recordings, broadcasts, published editions, etc. Copyright does not protect ideas, information, styles, or techniques. Copyright does not protect names, titles, or slogans. You will need permission from the copyright owner if you want to use anything made by anyone else. Best practice is to obtain written permission. The Copyright Act does not allow you to use material without permission if you can't contact the copyright owner. A copyright owner is entitled to commence a civil action in court against someone who has infringed his or her copyright and may be entitled to various remedies. Action must be taken within 6 years of the date the infringement took place. Final orders are granted after a case has been heard and put the court's decision about the issues in dispute into effect. Damages may be awarded to the plaintiff. This is a payment of money to compensate for the infringement. Damages are often based on the amount that the copyright owner would have been able to charge for the use of the material. The Copyright Act 1968 provides for individuals to be fined up to $50,000 per offence, and for corporations to be fined up to $250,000. The possible term of imprisonment of up to 5 years. Commission photographs are when someone pays you to go out and take photographs. Copyright will generally be owned by the photographer, but it can vary depending on factors such as employment, licensing agreements, or if the photograph has been commissioned. Photographs commissioned prior to 30th July 1998. Copyright will be owned by the person who commissioned the photo, regardless of the purpose. Photographs taken on or after 30th July 1998, the general rule on ownership depends on the purpose for which the photographs were taken. If the photographs were taken for domestic or private use, such as wedding photos or family portraits, the first owner of the copyright is the client, unless the photographer and client agree otherwise. If they were taken for any other purpose, egging commercial shots, the photographer owns the copyright unless the photographer and client agree otherwise. Generally, photographs taken before 1st January 1955 are not copyrighted and said to be public domain and can be used for anything. Public domain libraries can be found online. If they were taken for any other reason, commercial shots, the photographer would own the copyright unless the photographer and client agree otherwise. Copyright in these photographs will be owned by the person who commissioned the photo unless an agreement is signed to the contrary. Photographers may have a right of restraint when a photograph is commissioned and they do not own copyright. Right of restraint is the right to prevent the photograph being used for purposes other than which it was commissioned. Photographs taken in the course of employment. If the employee takes a photography as part of his or her job, the first owner is the employer, unless they have made an agreement to the contrary. Photographs taken for the government. Unless there is an agreement to the contrary, the Commonwealth, state or territory government is the first owner of copyright-created material or first published under its direction or control. Photographers can produce contracts to alter any part of this agreement with their clients. Physical ownership is different to copyright ownership. If you sell a physical framed photograph to a customer, that does not give them the rights to the copyright of that photograph. Copyright owners of photographs have the right to reproduce, publish, communicate, or broadcast their photographs. There is no right to perform or display photographs. You do not need permission from the copyright owner to exhibit a photograph in public unless you need to reproduce the photograph in order to exhibit it. Entering a photography competition? Read the fine print. You might be entering into a contract with your images that you might not want to. If you are on public property, you can photograph anyone or anything, including children. Out of professionalism, if someone asks you to stop photographing, it's best to respect their wishes. If you are on private property, you can be told not to photograph and even leave the property. However, if you have taken photographs already, they cannot tell you to delete the photographs as they are your property. Best advice is to remain calm and remove yourself from the situation immediately. Shopping centers, pubs, clubs, major sporting venues all usually fall under private property. However, it is illegal to photograph any defence installation in Australia under S82 Defence Act 1903, CTH. Your photos, camera and film can be confiscated and destroyed, and you can face potential fines or imprisonment. Generally, you can film or photograph police performing their duties in public. You may be told by a police officer that you cannot film or photograph them without their permission. This is not correct. If you were to say, "This is a public place and I'm allowed to film," will be enough for the police officer to let you keep filming. You should note, however, that you still have a legal obligation to comply with move-on directions. You also have a legal obligation not to interfere with the police or hinder them if they are carrying out an arrest. If the police ask you to step away because they say you are filming too closely, it might be better to just move back and keep filming rather than engage in a confrontation that could lead to your arrest. Mashups or collage creations incorporating copyrighted images need to be assessed against ownership rights and copyright exceptions, such as fair dealing, research and study. You can create mashups or collages under the fair dealing provision, research and study, but only while you are studying. To use copyrighted work in a mashup or collage outside of research and study, you must ask the copyright holder for permission. If you create a collage or mashup from a substantial part of an existing work, you may be in breach of copyright. There is no percentage by which you must change an image to avoid copyright infringement. The safest option is to create mashups and collages from works where copyright has expired, from Creative Commons licensed works or open resources. Creative Commons is a non-profit organization that helps overcome legal obstacles to the sharing of knowledge and creativity to address the world's most pressing challenges. Creative Commons provide Creative Commons licenses and public domain tools that give every person and organization in the world a free, simple, and standardized way to grant copyright permissions for creative and academic works, ensure proper attribution, and allow others to copy, distribute, and make use of those works. Thank you for watching.